What is mens rea, other than very difficult to prove sometimes? Mens rea is the second legal principle that most law students are likely to learn about in their criminal modules. Together with actus reus, it forms the underlying basis for criminal liability. Disclaimer: this video is intended for academic and entertainment purposes. Nothing within this video constitutes legal advice. I am not a lawyer. I am a recent LLB and diploma graduate, and this video is intended to help other students on their journey. I may be wrong on any and all of these points, but I have tried to be as faithful as possible to my original lecture notes and my own understanding of Scots law as a successful student. Case citations will be in the description. Hilariously, despite having just said mens rea forms part of the basis for criminal liability, and despite calling it the more fun twin in my last video, I have to immediately start by saying that mens rea isn't always necessary. There are some generally statutory offences, mostly road offences actually off the top of my head, which are known as strict liability offences. Actus reus and actus reus alone is sufficient in proving a strict liability offence. Most other cases, however, require dual parts. First, the prosecution has to show that the accused has committed the necessary physical conduct, the actus reus. Second, they must prove that the accused acted with a guilty mind and had the necessary mental element of the crime. Mens rea alone is never enough to prove criminal liability, because simply thinking of committing a crime isn't a crime. There are no thought crimes known to the law of Scotland. There's no one single definition of mens rea because, like actus reus, it's broad. Encompasses most crimes, and what would constitute mens rea for one crime won't suffice for another. So, for example, the mens rea for theft would generally be to temporarily or permanently deprive the rightful owner of some property of theirs. Assault, on the other hand, requires something of evil intent, though the precise meaning of that phrase is dissected in the Lord Advocate's reference number 2 of 1992. It's not completely relevant here to dig into the specifics of why the Lord Advocate seems to find that phrase unhelpful here, but it is a good read if you want the particulars. It is worth saying, though, and the Lord Advocate says so himself, that the intention is not the same as motive. Though that may be harder to get around, I believe the point he's trying to make is that it's irrelevant what reason the accused had for doing something. What matters as to mens rea is what they intend to happen by their doing something. We're looking at what the accused wanted to or expected to happen by their actions, not what prompted their actions. Though what prompted the actions may be a relevant defence for the accused to lead, that's its own topic. Cunliffe against Goodman, 1950, provides quite a coherent definition for being 70 years old and English. For those of you who are particularly new, Scotland and England have different jurisdictions, but English law is considered persuasive in Scotland. So I think it's fine to lean on this case, and also it came from my original lecture notes. So my lecturer, who is a great deal more qualified than I am, thought so too. Cunliffe states that an intention connotates a state of affairs which the party intending does more than merely contemplate. It connotates a state of affairs which, on the contrary, he decided, as far as in him lies, to bring about, and which in point of possibility he has a reasonable prospect of being able to bring about by his own act of volition. With that clarified, I would hope you understand what is meant by mens rea, but that prompts a further question. As mens rea needs to be proven to convict an accused of most crimes, and as mens rea is the mental element of the crime, how does anyone prove what the accused is thinking? Surprisingly, solicitors are not mind readers, and nor are the judiciary. Certainly there are occasions where the accused may confess and simply tell the court what their thought process had been, but that cannot be relied on for every case. Generally, the prosecution will seek to draw inferences from the accused's behaviour, This may be things that they have said or done surrounding the offence, an admission they've made under caution, or be drawn from any other relevant circumstances that support some sort of assertion about the accused's mental state. For example, the prosecution may have evidence of several short phone calls minutes apart between two co-accused right before and then after an alleged offence. This may be used to demonstrate an anxious mental state. What may have caused them to be anxious? Well, the prosecution might suggest it's because they've just taken part in an offence. Alternatively, some crimes allow for a mens rea of recklessness or reckless indifference. That is to say, a person's mental state was one of complete disregard to the consequences of their actions, particularly as to whether someone is hurt in the process. See Quinn against Cunningham, 1956, as an example, wherein a cyclist was seen to be riding their bicycle in a reckless manner, which resulted in their colliding with a pedestrian who sustained minor injuries. The accused in that case did not specifically intend to hit the pedestrian, but they were behaving to the effect that their conduct would not be demonstrated by a reasonable and prudent person. For certain offences, that is a sufficient mental element. More seriously, this line of reasoning may be utilised in charges of culpable homicide, wherein by definition the accused did not intend to kill anyone, but a death has occurred regardless. That would clearly be reckless. Finally, there is a third kind of mens rea, but it is rarer than the first two. Negligence can be sufficient mens rea subject to certain statutory offences that involve some element of carelessness. This is usually seen as less quote-unquote wicked than recklessness. Negligence pertains more to an individual's failure to appreciate risk as they ought to have, or as a reasonable person would have, rather being totally indifferent. I don't have a case to hand demonstrating this well off the top of my head. I would suggest negligence as mens rea plays the largest role in road traffic offences though. For example, if a road traffic collision that results in a death is caused by a driver's inattention to the road because they were texting, that driver may then be charged with criminal negligence. They had a duty of care to other road users to behave safely and they haven't done so. This brings me to the end of this video. This one was a little shorter than the first, as trying to do a general overview of mens rea rather than delving into the particulars of the mens rea for specific offences is actually quite difficult. But I think this is a good starting point for the concept. Being built off my own lecture notes too at the time, I think this is probably all first years are taught at the start regardless. So if it was enough for me, it's enough for ye. I still don't really know how to finish these videos, but if you found it useful or interesting in any way, I'll be posting more when I have time and energy. I think I'm planning to cover art and part liability next, so if that's of interest to you, feel free to subscribe.